suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And that means that David Whiting not only is here to help you with your calls, but for the first time in a very long time is here with me in the studio. David Whiting, is this a ghost I see before me? Who are you?
An apparition. I'm very well, thank you. I'm sitting, it looks like a school desk as we handle safe distancing.
Hello again, Facebook, or please tune in if you're not yet to ABC Radio Melbourne's Facebook page. Great to have you streaming because you can see, look, there he is. You can see there's David Whiting over there. Wave to the camera, David. You can't quite tell from the wide shot. I'm here. There's me, and he is all the way over there in the far desk.
Indeed.
Yes.
Out of Siberia.
That's right. In Siberia, where we can't give each other any germs. How have you survived? Is it nice to be back in the real world a bit?
This is the second day I've worn a suit in 8 weeks.
Has it just been Trekkie decks the whole time, has it?
No, I don't actually own any Trekkie decks, but it's been far more relaxed. I'm enjoying what I'll call normality. Mm-hmm. I've been coming to town once a week to the office. Some things you just can't do at home.
What have you learned? What do you think you'll take into your legal practice, and what won't you?
I've always been concerned about working from home and work ethic and attitude to work.
Trusting your employees.
Yeah, that's the answer.
Yeah.
I'm far more relaxed about that. My view will be that when we get back to work, there will be more, so I'll say to people, if you want to work from home a couple of days a week, it works for me. I think that I'll be looking to make sure that everybody's at work on 1 day a week. Mm-hmm. Because otherwise you lose the team element. You just become a group of people with the same employer rather than a team. I see the difficulty, though, is in hiring new people. How do you get people to become part of the team?
Oh, yeah.
Otherwise...
If you're never there.
Yeah, I'm talking to a barrister this morning but that I really see them as contractors brought in for a specific task and then they leave. Mm-hmm. But as an employee lawyer or an employee in the firm, you're trusting them with your name and your letterhead. And, what you normally do is you hold them very close and over time they get more and more discretion.
You let the rope out.
Yeah, you do. Yeah. You do. No, that's what I've learned.
That'll be a challenge. We got any homework or answers to answer?
We have no homework.
Questions to answer, I'm sorry.
But we did have a call last week or the week before called Anna, who ran a family counselling business in St Kilda, and she'd had to close her business as a result of COVID-19. Mm. And I quoted to her from the Commonwealth Government guidelines on rent adjustments. And the suggestion in the Commonwealth Government guidelines was that the rent would be adjusted on the same basis as the turnover of the tenant. Yes. They've not been adopted by the state government. There are 14 different factors that you take into account, but there is no anticipated direct link between loss of turnover and rent reduction. So it's I think it's a much more nuanced and a much more balanced approach.
Well, that's good to hear.
Yeah, well, I was worried about the landlord because the expectation was that the landlord had to wear a large chunk of it, and they don't all have the ability to do that.
Let's get you some answers. 1300 222 774 is our number if you'd like to seek some advice from David Whiting. Abdul is first up in Blackburn. Good morning, Abdul.
Good morning, how are you?
Well, thanks. Go ahead.
Good. Look, I've owned a beach box down in the Mornington Peninsula for about 15 years.
Congratulations.
Thank you. Well, yeah, kind of. The Mornington Peninsula has sent out a letter to all beach box owners that if you don't live in the Shire, you can't own one and you have to get rid of it by 2025.
Really?
Yes, and there's a bit of an uproar. There's, I think, don't quote me on it, about 1,300 boat sheds along the peninsula, and about half are owned by people who don't live in the Shire. Now, what do I do? Can council do this? It's on Crown land.
It's on Crown land, but you'll find that the Shire is probably the management committee for the Crown land.
Right.
So it's a question of what discretions they have as the manager for the foreshore.
Okay.
Are they perpetual leases? How long do you normally get a lease for a beach box?
Well, funny enough, we thought we had a 99-year lease on them, and me and a few other boat shed owners, we thought we had a 99-year lease, but there's nothing stating that. And when I called Cancel, she said, no, you don't have a 99-year lease. That's why we're saying now we're going to have a 10-year lease period.
So what did you pay and when?
I pay. What do you mean? Sorry.
So how did you get it?
What did you
Abdul?
get?
That's the question.
Yes.
Well,
It's
okay. I bought it about 15 years ago, and it's like buying a car when you buy one of these sheds.
Meaning?
You do a transfer fee with the Cancel, which at the time was about $2,000, and they give you a list of rules, what you can and can't do. And it's not like buying a house where there's a...
You don't get a title or anything? What do you get?
No, you don't get nothing really.
You get
just
registered as the occupier of the space.
That's right.
And
yes.
so the real question is, I mean, I would be looking, Abdul, at the Local Government Act and find out what your rights are. I probably would have thought that it's something like this, something political would be appropriate. But I do remember that when these beach boxes came out, that's not right. I can remember beach boxes in the past, you had to be a resident to have one.
That's right. Yep. And then they opened the floodgates at a period of time, and that's when I bought it.
Can I ask which beach, which suburb?
It's in Rosebud, my little boat shed.
Yep.
So they're not very expensive down there, and but the top end they're a lot more expensive. So if we all have to sell up, there's going to be a bit of a fire sale down that way.
It depends whether you're the first to sell or the last to sell, or they just take it from you, Abdul. Why don't I'll take some homework, but I would have thought it's more a political issue than a contract or property law issue. But we'll have a look.
Abdul, on text, someone's suggesting if you own a beach box on the peninsula, then you might be able to afford a lawyer. But
well,
was it expensive? You're clearly reluctant to tell me the sum, and I get that. But was it expensive?
No. I'll tell you what. Our sheds in Rosebud, they're the cheapest on the peninsula.
Okay.
They're between $90,000 to $100,000 now. Okay. Now, back in the time when I got it, 15 years ago, it was about $45,000. So they're not great investments. Then, you go to Brighton and those other wealthy suburbs. They're the ones with the money.
All right. Well, we'll get some homework, as David suggests, and also maybe ask the council. I'd ask the council for any documentation that explains the original agreement in the first place.
The rights you acquired.
Yeah, the rights you acquired. Abdul, stay listening, stay in touch, because we might get an answer for you. Lots of comments coming in here, David. You may have a reflection on it. Boat sheds are owned by the Crown. I know this as I was the manager of a foreshore on the Mornington Peninsula, says Mel.
The general proposition is you own the site on which it's constructed, and that they have the right to occupy the space.
Okay.
Yep.
And also on text, in some parts of the Shire, these conditions already apply to ownership of beach boxes. This is just bringing the others into line.
Okay, which makes sense.
Which would make sense as well. Okay, Anthony in St Kilda, good morning to you.
Good morning, Virginia, David. David, as a percentage, what's the minimum that you can leave your offspring of your estate so then they can't contest the will?
We were just talking about this off air. Welcome, Anthony. Go ahead, David.
There is no minimum, Anthony. It depends upon what you leave, the needs of the person who's not happy with what it is you've chosen, and the needs of everybody else who's a beneficiary under your will.
Okay.
You're supposed to be wise and just. And wise and just takes account of those factors, not a percentage.
Oh, okay. So I've recently repartnered and I be leaving the bulk of my estate to my partner. And I was just wondering whether I could leave a minimum amount without my daughter contesting it. She's an adult child, 24.
Anthony, there's an expectation that you will give priority to your life partner. So that if you look at the cases, that's the expectation.
Okay.
What you might consider doing, and what a lot of blended families do is actually look at a two-stage will.
Okay.
So you come along and say, well, look, So there's an expectation if I'm leaving the bulk of my estate to my partner, then I expect that when my partner goes, some of it will come back to my side of the family. So why not have that discussion with your partner about what happens if I inherit from Abdul, then do his children get anything back?
Okay.
When I die. Yep.
Yep. All right. That's great. Thanks,
Anthony,
David.
are you happy to leave your daughter something at all?
Oh, absolutely, yes.
Yeah.
I intend to, yes.
Okay.
She's been provided in the past, so,
Okay.
yeah. No, that's fine. Thanks very much.
No worries.
Then Anthony,
Good on you, Anthony. Yes.
The last thing I would say is, Anthony, if you believe that you've already adequately provided for her, then you've got to make sure that your executor has that information.
Okay.
Because there's no point having an executor who you want to defend a claim that a child might make, but has no information in which to do so.
Good on you.
Okay.
Thanks for calling,
Thanks,
Anthony. Peter's in Ferntree Gully. Good morning.
Good morning, both. David, I've got a son who owns a townhouse. He, 6 months ago, allowed a friend of his to come in and share the property with him, making a small contribution per week towards the outgoings and so forth. My son is now interstate with work, and the remaining friend in the townhouse has had his girlfriend over a couple of times, and she parked in the garage, and apparently the garage door unhinged and damaged her car.
Yes.
Is my son in any way liable for that, and whose insurance is it meant to claim and so forth?
My expectation is that your son would have a responsibility as the owner of premises with a faulty garage door, unless you can point to something that the friend or the friend's girlfriend did that caused it to fall.
Yeah, no. Is that should the claim be made on his home insurance or on her friend's car insurance? Or
Well, if she
like
makes a
the-
claim on her car insurance,
Yes.
her car insurer will seek the money from your son.
Right. So my son should not make a contribution to her friend's excess.
Well, otherwise it just simply goes round and round. My view is that you should make a claim on your own policy, or your son
Right.
should make a claim on his
Yes.
policy.
And he's not and that other person in the unit is not a tenant.
No, but she was an invitee. She was a guest in the premises, and she entered the
Yes.
premises and parked with the authorisation of the person that your son left in charge,
Yeah.
and there was a fault in the premises that caused damage to her car.
Right. Even though it's not my son didn't know about the fault in the garage door.
No, well, nobody did. The question will be is whether there was an obligation. Was there an obligation? The answer is yes.
Yes.
Was that breached? The answer would be who knows. What caused it to fail? What was the problem? Was it readily apparent? I mean, your argument could be that none of this was apparent,
Yes.
that there was no indication that there was a fault in the garage door, that it wouldn't have been seen by anybody, or not seen. You needed technical skills to understand it was faulty.
Yes. So really, my son should put in a claim for his own home insurance. Is that right?
Well, I would.
Yeah.
Okay.
Yeah. Okay.
Good luck.
Thank you. Thank you very much.
Nice to hear from you. Thanks for calling in. Peter's with us from Benalla. Hi, Peter.
G'day, how are you?
Good, thanks.
Thanks for taking my call.
No worries.
David, I went to VCAT over a bathroom matter and they gave me $3,000. The extent of the damage is a lot worse than that. Do I take him back to court or do we go back to VCAT? VCAT wasn't very, very good, I must say.
Who's the him in this?
The builder, the man who did his bathroom.
Yeah, that's right, but he's not qualified or no insurance, anything like that. What I want.
So, Peter, here's the problem, right? We have this concept where courts and tribunals are unwilling to hear the same thing twice. So you would need to look very carefully at what your claim was, how you expressed it. So you may have made a claim for $10,000 and got $3,000. Well, that's what the tribunal has given you in respect of the whole of your claim. So you might need some assistance to actually see whether there are additional claims between you and the person you engaged that weren't included. And if they're not included, you can make another claim. But if you If you made a claim for bodgy work done in your bathroom, and all you did when you got there was talk about the vanity, then I'm really very sorry. You're looking at the claim that you made and you've got an amount of money. So you go off and get some advice on that question. You can go to VCAT and you can ask them for a transcript. You'll need to pay for it. So it's really, if you didn't handle VCAT as well as you should have or could have, you can easily end up with a less satisfactory outcome.
Okay, could I go to the magistrate's court?
No, because you've already had a hearing in relation to the damage to your bathroom.
Okay, all right, thanks, David. I appreciate it.
Sorry about that, Peter. Good luck. Sean is in Oakley this morning. Hello, Sean.
Yeah, hi, how are you?
Good,
Well.
thanks.
That's good. Thanks for taking my call. Basically, I'm calling in regards to details of an out-of-court settlement that a fellow employees got from our employer. I was part of the same contract that these employees were all on. Now, I've been sent details of this out-of-court settlement by accident. Am I able to use that those details that I've been sent to launch my own personal court action or use it for my own personal...
Okay, Sean, what you're saying is that there were a group of employees who were engaged on the same terms.
Yes.
Not under the same contract. You all weren't parties to the same document, but rather you and I had contracts that were identical, apart from our names.
Yes.
Okay.
Yeah.
Now, you need to understand that the fact that they've reached a settlement with somebody else doesn't guarantee you the same amount of money or the same outcome.
Yes.
So there'll be terms of settlement between the employer and the employee that are expressed to be made for business efficiency reasons and with a denial of liability. So the fact that they settled with Fred or with Mary isn't evidence that they owe you a cracker, and the amount of the settlement with Fred or Mary is no evidence that even if you are successful, you will get that. Sure. Now, you are entitled to use those terms in a negotiating sense, but all they are evidence are that there was an agreement reached between two people.
Right. But but I can use it to go to my manager and say, this is what happened with these employees. Why hasn't it happened with others?
Yes, you can, but would you look after yourself before you start looking after the world, Sean?
Well, I suppose charity begins at home, I guess. But
well,
I wouldn't discourage altruism here, David. Come on.
Okay, well, all right.
Spoken like a real lawyer, eh?
Indeed.
What do you want to go and say, Sean?
Well, I just want some more clarification, because on the deed of settlement, it just mentions the contract that was terminated by the employer. And we were all on that same contract at the time. So I would want some more information as to why...
But you've not been terminated.
No, but the contract was terminated. We were working under a contract for a while, and then that got terminated, and we reverted back to hourly rate. So it was a peace contract.
All right. Sean, go for your life. It's part of that. You can have the negotiation. I just can't guarantee you an outcome.
But he's not using something illegally acquired.
No, there will probably be a breach of confidentiality. So I would be much happier if it came inadvertently from the employer rather than inadvertently from the other party to the contract.
Does that change what you're going to do, Sean?
So if you look at the agreement and it's said to be confidential and you got it from the employee who got some money, then they could be sued for... They may not be, but they could be sued for breaching the confidentiality.
I actually got it from the group that was representing the employees.
Oh, well, that's not your problem then, is it, Sean?
There you go. Free and fair. Good luck.
All right.
We will send St George off to fight the dragon there. Hey, David, I did want to mention to you and ask you about a really thorny legal issue just before we head off and talk to Marcus Padley. And that's about all the conditions now wrapped around that incredibly generous $53 million that was raised by the comedian Celeste Barber and given to the Rural Fire Service at the time of the bushfires. That matter now is in court in New South Wales about how and in what way the Rural Fire Service can get access to that money and what they can use it for. Celeste Barber was raising it in the mistaken belief that it would go to the RFS and then distributed to people who were affected by the fires, householders, people who lost their homes. And it can't be, because it went to the trust. It can only be used in a very restricted way. What's going on there?
Well, you say I'm raising money for a particular purpose. You set out what that purpose is. You would, in the normal course, document it. And they are then the rules for the distributions.
She was unaware. She thought that seemed like the most sensible place for it to go, to the RFS, and they can therefore distribute. It turns out they can't distribute, and they're as hamstrung as anybody else because of the nature of the trust arrangements that constitute it.
This was never intended to be a fundraising for a discretionary pool that someone who could decide where it was to go.
I think it was. I don't think it was intended just to go to the RFS.
No, there was a trust deed. So when I say, if I set up a trust to raise money for a particular purpose, as Celeste did, somebody on her instructions and together with her would have come along and said, these are the rules for the dealing with the money.
No. That was the problem. People just wrote cheques to the RFS and they're stuck with them going, well, we can't distribute this in the way that you'd like us to.
Well, yes, but it's $51 million. The RFS can use the $51 million.
For themselves,
but
yes.
Because of the amount of money, people think it should be, some people think it should be spent more widely, and that's the difficulty.
And why is that so difficult? What is it about that sort of setup that makes that hard?
If I was to give money to a particular named charity, then I do so on the basis of the purposes that are contained in their constituent documents.
Yes.
It's not for someone else to say, no, there's a greater need over there. That's the problem. So it's the law of unintended consequences. If it had been $1 million or $5 million, nobody would have batted an eye, and the $5 million would have stayed with the RFS, and it would have been used for the purpose of improving their equipment and facilities. It's $50 million, and people are now saying, well, that's too much for them. But there are some charities who've got lots of money and some that don't.
It's also the wishes of the donors, I guess. I mean, the donors were giving money, not knowing that full story, that the consequence of the money going to the Rural Fire Service. Yeah, exactly.
And so do you want to go and ask each individual donor?
Yeah.
That's a waste of time and money.
Well, no, but you need to be clear in the first place. Well, this is all hindsight, of course, but it's a fascinating area and a case, and we still don't know what happens to all that money. David, great to see you. Did you like your time at the little desk?
I did. It reminds me of school, but that's okay.
Well, this on Facebook, this comment's coming in. David at the desk is both hilarious and a bit insulting to the great man. I am, as always, enjoying the incredible knowledge of David. Keep up the good work, and I hope he gets to present at the grown-ups table very soon. We'll let you back to the grown-ups table soon, I'm sure.
In due
course of things. Facebook, great to have your company. Thanks so much for tuning in with us today. Say goodbye to David. There he goes. And he'll be back next week offering you free advice, this time next Tuesday as well. All right, let's see what Marcus Padley has to say as David Whiting destroys the desk on the way out. Honestly, you just can't have visitors here. Leave the headphones behind. Yes, thank you very much.